For pronouncement of judgment.
In the light of the discussions made above, this court is firmly of the view that the petitioner has not been able to make out a case for enabling this court to issue directions to the state respondents to retrospectively regularize the service of the petitioner post-retirement. Furthermore, having held that this court under Article 26 of the Constitution of India does not have the power to direct regularization and or observation in service unless the recruitment itself was met regularly and in terms of the constitutional scheme. And also having considered that the petitioner does not fulfill the conditions to be regularized in service as per the scheme formulated by the government and therefore cannot be regularized in service, this court is of the view that it will be futile to delve into the petitioner's claim for pension and pensionary benefits. There is no merit in the writ petition and the same is accordingly dismissed. No host. Yes, Mr. Siddhi.
May I place a lot? My lord, I may be allowed to move an unlisted anticipatory appeal application.
Unlisted anticipatory bill. Okay.
Apply.
But anticipatory bill, Mr. Siddhi, it is to be moved before court number 2.
Lordship, very well, I can seek permission there.
Yes, kindly.
I am going by the protocol.
Thank you, but I think it will be more appropriate.
Lord, I will do that.
May I please, Your Lordship?
Yes, please.
Your Lordship, I beg to mention hearing item number 19. My seniors in disposal, let the matter be come up after vacation. Hearing 19.
Who is your senior?
S. Tamjun.
Okay. Mr. So-and-so, then a counsel, submits that Mr. S. Tamjil, the leading counsel for the petitioner, is indisposed and therefore seeks adjournment of the case after the summary listed accordingly.
Much.
Okay.
Much honoured. May I please, Lordship?
Yes.
I beg to mention item 17 of the hearing list, my lord.
17.
Yes, my lord. I am for the private respondents here, my lord.
Yes.
Kindly let this matter be listed after the vacation, my lord. Come prepared with the item 16. So,
16.
I'm mentioning item 17, my lord.
Okay. Item 17. You are the counsel for the
Private respondents, my lord.
private respondent. Private respondent number
5, 4, 5, and 6, my lord.
Mr. N. Longcomer, the Lieutenant Counsel for the private respondent number 4, 5, and 6. 6 adjournment of the case after 2 weeks. Prayer is allowed, listed accordingly. Okay.
Obliged, my lord.
May I please, Lordship?
Yes, Mr.
Lordship, I beg to mention item 18,
Item
18.
18, yes.
I am for the petitioner.
Yes,
Lordship, may I plead that this matter be listed after vacation?
after 18. Mr. Wati Jamia, the Lieutenant Counsel for the petitioner. Six adjournment of the case for 2 weeks. Prayer is allowed, listed up to 2 weeks.
Obliged.
My lord, item 20.
Yes,
Let this matter be listed after 2 weeks.
after 2 weeks.
My lord.
Mr. M.T. Romchar, the Lieutenant Counsel for the petitioner, six adjournment of the case after 2 weeks. Prayer is allowed, listed accordingly.
Much obliged.
Yes.
Your Lordship, this is for item number 6.
Let it come as per the list.
For motion, item number 1.
Lordship, by this,
See that. Yes,
by this petition, I am challenging the order of the case. Lordship, by the judgment of the Supreme Court, petition.
Just wait.
There is
For motion,
judgment
item
that
number 22.
Just wait. Let us first see item 22.
For motion, item number 22. Yes.
Uh, Against the order of Kate,
Lordship.
it has to be listed before division.
Lordship.
Okay.
Yes, Lordship.
So, both item number 1 and 22,
22.
which are motion matters, this may be listed tomorrow.
Lordship.
Okay?
Lordship.
Yes. 1 and 22.
Before to be Lordship. Much obliged.
For admission, item number 2.
Yes.
Yeah, please, Your Lordship. Lordship, the opposite counsel for a respondent for a IOC counsel is from out of station. He comes from Gauhati. And actually, on the last occasion,
Well, why don't you mention your case? Why are you mentioning on behalf of the opposite counsel?
Lordship, it was fixed on 20 July, and it has been wrongly
20
listed.
July.
Yes, Lordship.
20 July. So, you mean to say that this is mistakenly listed?
Your Lordship.
That's order. Oh, 26.
It was supposed to be 27, Lordship.
Okay, maybe there is some. So this was supposed to be listed on
27.
27. On the prayer of the Gun Council for the parties, listed on 27, 2022.
Much obliged.
For admission, item number 3.
Please, Your Lordship. I have instruction to appear in this matter. I'll be filing my Bangatama today, so it may kindly be listed on Thursday or Friday for hearing.
Who's for the other? Yes, Mr.
My lord.
Murli,
Yes, my lord.
the hearings are completed.
Yes, my lord. Plating is completed.
Your good name?
Kinritabo, my lord.
Your good name?
Pakin Ritabo.
You are appearing for
I'm appearing for the petitioner.
petitioner.
Yes, my lord.
And Mr. Sajjan Murli, you are for
Respondent is my lord.
Union of India.
My lord.
Union of India.
Yes, my lord.
What is the matter about?
Service matter, my lord.
Service matter.
Yes. And the petitioner has voluntarily get retirement discharge from the service. Yes.
Discharge from service.
Yes. And now he is seeking for
Instead,
reinstatement. A lot of last occasions also they have sick time and so many times they are seeking adjournment.
you are
And
for hearing.
yes, my lord, I'm ready for hearing, but my learned friend is praying for sometimes. So the last occasion on 30 of May, today is a last chance is given, my lord. There's another court is given last time. My lord.
It was the 35.
35, my lord. Yes.
No last chance was given. Anyhow, have you filed your Pakala,
I'll be filing today, my lord.
Mr. Spencer? Cleveland Council. submits that he has been recently engaged to represent the to represent the petitioner, and he will be finding his power in the course of the year. Start. It is submitted by the parties that hearings are completed. The matter. Use the microphone. Use the microphone. Admissionary after the summer.
Much later.
For admission, item number 4.
The state has filed affidavit this morning, Lordship. I have received a copy. If I may be given 3 weeks' time to file reply, Lordship.
And ma'am, your vote?
Lordship, I'm for respondent number 6. In the meantime, I'll also file my affidavit, Lordship. I'm yet to file.
The state has filed.
Yes, Lordship.
Neither is there. So, Madam, he is very responsible petitioner. Submits that he may be allowed 3 weeks' time to file affidavit in reply to the affidavit in opposition filed by the state respondents.
Lordship, not the additional opposition, but additional affidavit, Your Lordship.
For additional
Yes,
affidavit,
yes.
Lordship, additional.
the additional affidavit filed by the state. MS Rachel, the then account for the respondent,
Number 6, Lordship.
number 6. Also 6 for 3 weeks' time to file affidavit in opposition. Listed after 2 weeks.
Much obliged, Lordship.
For admission, item number 5.
There's the same thing, pension,
No. Illegal discharge.
illegal discharge.
My lord. My lord, the petitioner, he was enrolled in the Assam Rifle on 19/9/2007. Then Annexure 2, page 16, my lord. This is the true cause. It's like a departmental proceeding. True cause without any material against the petitioner. I may be allowed to read out, my lord. You were enrolled on 19 September 2007 in Assam Rifles. Thereafter, in your service of 7 years, 11 months, and 14 days as on such and such, you have incurred full rate interest in your procedure. The details are 1, Assam Rifle Act 26B,
Page, you are writing page?
page 16, show cause notice. Statement of offenses without suppressing cause, overstaying leave granted to him.
Mr. Yangawati? Yes. I think this is the case where last time you were supposed to get some instructions
Yes.
on the writings.
Yes, sir. I have.
Yes. So the other side might be given an opportunity also.
I have got only the review.
Let us.
Lordship, this is the Assam Rifle regulation. And section 108, Lordship. I may read the whole thing. May I read, Lordship?
discharged on ground of red ink entries. A subordinate officer, under officer, or other individual person who has incurred 4 or more red ink entries to be recommended for discharge from the service on the ground of unsuitability, subject to the following conditions. A. After an individual has earned 3 red ink entries, he shall be warned in writing that his service will be liable to be terminated by the competent authority if he earns 1 more red ink entry. Such a warning letter shall be issued to him by the concerned sector commander through the commandant of the individual. B. Each case of individuals having earned 4 or more red ink entries shall be examined on its own merit, depending upon the nature and the gravity of the offenses, and the aggravating circumstances under which these were committed. The authority competent to sanction discharge under the bara shall record reasons for ordering the discharge or otherwise. C is not relevant, Lordship. B. Before taking the final decision to order the discharge, the person concerned shall be informed through a show cause notice that his retention in the service is considered undesirable for having incurred 4 or more red ink entries. Thereby,
So it was consequent to D that this show cause was issued.
yes.
Yes, you filed an affidavit.
Yes, I have.
Proper affidavit.
I have filed.
Okay, and this is which regulation?
Assam Rifles University.
Kindly actually mention all this and then file a proper affidavit. Give him an opportunity at least. Okay, because this is not a part of your academic proposition. Yes. Mr. Yamawati, the England CTC shall file a detailed affidavit as to how and Assam Rifle, this is Assam Rifle.
Assam Rifle.
Assam Rifle personnel is discharged on the ground of red ink entries. Stop. The affidavit shall be filed within a period of 2 weeks.
Let us come up after vacation.
Within a period of
After the vacation, Lordship.
within a period of 3 weeks from today. You actually file affidavit, you serve him a copy. Citing. This
I'll
would be
fill my
necessary.
I'll fill my affidavit.
Okay. Okay.
Much obliged.
For admission, item number 6.
Your Lordship, the railways have entrusted this case to Advocate Y.P. Gupta, and so a time may be given for filing the Vakalatnama.
Who was appearing before?
Nixon Killer, Lordship.
Affidavit has been filed.
Yes, Lordship. Pleadings are complete, Lordship.
Mr. So-and-so. Mr. Mitchell. Mr. Y.P. Gupta has been recently engaged to represent
Railways.
Respond-
the railway respondents. And therefore seeks for a week's time to file power and take necessary steps. Where is allowed.
Much.
For admission, item number 7.
Yes.
Please, Your Lordship. Lordship, the matter was listed for admission hearing. The principal counsel is indisposed.
What is the matter of?
It's about appointment, termination of appointment.
Commissioner was terminated.
Yes, Lord.
From what law?
on the ground that ban on appointment of relatives after availing voluntary retirement, Lordship.
And you are against that?
Lordship, the father of the petitioner retired, taking voluntary retirement.
So whether the son has a right?
Lordship, he was not appointed on the basis of that, Lordship. Nothing, nowhere in the appointment letter it is mentioned that he has replaced his father.
Okay. But by implication?
He was appointed on a temporary basis, and after the district screening committee recommended his name, he was appointed, Lordship.
He was appointed after the retirement of his father. Okay. When do you want it?
After 3 weeks, Lordship. Lordship, there is an interim.
Mr. Sir, the next guy. Mr. N.K. Lushon, the leading counsel for the petitioner, is in this post. And therefore, since the general case, after 3 weeks, where is allowed? Listed accordingly. So the interim order passed the years of principle to the next return.
For admission, item number 8.
Yes, Mr. Trumpo, what is this?
Your Lordship, this matter is ready for admission hearing, Your Lordship. And mentioning on the pleadings are complete, Your Lordship. And mentioning on behalf of V. Jimo, Your Lordship. So this may be listed after vacation, Your Lordship.
Okay. It is submitted by the examining counsel to the parties. That pleadings are completed. Therefore, the matter can be concluded. Listed in the interim course.
Lordship, this in interim.
The interim order shall continue to the next.
Much obliged.
Obliged, Lordship.
For admission, item number 9.
Yes.
May I please, Your Lordship, I'm praying for the petitioner. I found Vagatnama this morning.
Mr. Solo,
Lordship.
what is the case about?
Lordship, they are asking for extended insurance. Your
I am
Lordship.
asking you, what is the case about?
Your Lordship, I'm for the state, Your Lordship, SBI.
You're for the state.
Your Lordship.
Now, what is
State,
the case about?
State Bank of India, Your Lordship.
What is the case about?
Lordship, they are asking for that extended insurance issued to the for the father, Your Lordship. This is father, Your Lordship. Lordship, I'm for appearing for the SBI, Your Lordship, and it has not been remitted to the account yet, Your Lordship, and they are seeking for that, Your Lordship.
It has not been.
Remitted, Your Lordship. It has not been transacted to the account still yet, Your Lordship.
But as it is, you're ready to.
Lordship. Lordship, response number 4 is the insurance for the
Yes, what is your
My prayer is, my Lord, respondent number 4, the director,
You're for
directorate of.
no,
I'm
Your
for the
Lordship, they are for the
petitioner.
petitioner, Your Lordship.
My prayer is that this court may be pleased to direct the director of Indian Army to file affidavit on why the insurance amount is not yet credited to my father account.
Your Lordship, here we have filed our affidavit, Your Lordship, for the State Bank of India, Your Lordship. We have made amendments that the amount have not been remitted, given in the account. So
You have remitted?
no, it's not. It has not been remitted. I mean, Your Lordship, Your Lordship will come to para 5, Your Lordship, or 5. Your Lordship, the insurance has yet to become to the account, Your Lordship, account of the deceased father, Your Lordship, of the petitioner's father, Your Lordship.
Who is to remit? Who is to remit that amount?
Your Lordship, the insurance,
The insurance.
yes, Your Lordship.
And you are for the.
State Bank of India,
Whether
Your
insurance
Lordship.
is a party?
No, Your Lordship. Insurance is not a party. Insurance has not been made a party, Your Lordship. The State Bank of India,
Why you have not made insurance as a party? When your claim is against the insurance through the SBI?
Well, the director of Indian Army is a concerned authority, since this is under Army, under the Indian Army.
Then why the question of insurance?
Lordship, it's an extended army insurance, Your Lordship.
Are you appearing for the petitioner?
Yes, my lord.
Are you appearing for the petitioner?
Yes, my lord, I'm going for this. I'm engaged recently, my lord.
Who was the counsel for the petitioner earlier?
Surya Das. He's from Kolkata.
So yeah, that's.
So you will be appearing for the petitioner.
Yes, my lord.
The pleadings are completed?
Yes, Your Lordship. Pleadings have been completed, Your Lordship.
Mr. So-and-so? Sir, Minister, he has been recently engaged by the petitioner. He has been recently engaged to represent the petitioner, and therefore 6-4, 2 weeks time. Where is the law? Listed after 2 weeks for admission hearing.
Lordship.
My lord, my prayer is that respondent number 4 may be directed to file affidavit on why the insurance amount is not credited to my father's
It's all
account.
right, we'll come to that. We'll come to that. Who is respondent for?
No one is appearing, Your Lordship.
Any other person?
Lordship, notice have been completed upon respondent number 4.
Who is respondent number 4?
The director, Your Lordship. Directorate of Indian Army, Your Lordship, CTC.
Where is CTC? Yeah, what we only. Whether any order passed stating a notice incomplete? You are Pakinri Akpo.
Yes, my lord.
You have appeared even last year since May.
Just as a proxy counsel, my lord.
Here it does not show you as a proxy counsel. It shows you as a counsel for the
I was appearing on behalf of Surya Das, my lord.
Mr. Yamawati,
Bishop, I have not received any copy of the petition also.
yes, you have a copy of the petition.
Okay, my lord.
Okay, cancel that vote. We'll show your presence. Respondent for
Indian Army.
Mr. Yamawati, the Leonard CTC. Appears for the respondent number 4. And submit step. He is yet to receive a copy of the written petition. So, the Leonard Council for Petitioner is directed to send a copy of the written petition to the Leonard CGSC when in the course of the day.
So within 2 days.
Within 2 days.
With extra copy, right? Extra copy. Yes, I have to send a copy to the respondent.
To save a copy. What was the last line?
The learned counsel for the petitioner is directed to serve a copy of the writ petition to the learned CGS.
Have to copy.
Serve copies. Serve copies. To the learned council for the to the learned CGC within 2 days from today. Listed after 2 weeks.
March.
For admission, item number 10.
May I please, Your Lordship?
Yes.
Your Lordship, I'm mentioning on behalf of VGMO, Your Lordship. He has some personal difficulties today, and here the pleadings are complete, Your Lordship. So this may be listed after vacation.
Lordship, this was to be taken up for admission
What is the matter?
hearing. It's with regard to assessment of damage compensation. The three buildings of the petitioner had to be dismantled for the ongoing road construction. So compensation was assessed at 11,48,605. Now what happened was state respondents, without informing the petitioner, somehow released the amount to the private respondent. And now the state respondents also directed the private respondent to return the money to me, but
Why the private respondent has returned the money to you?
no, only through the state respondents paid on two occasions some amount. Two lakhs on one occasion, and then 40 lakhs on the
40,000.
40,000 on another occasion. But then the matter kept on tracking, so the petitioner has been compelled
So
to.
I think the case is all about the state government recovering the money from the private respondent and handing it over.
Yes, Your Lordship. That is my only prayer. That because they are now claiming the private respondent when they had paid out the money to the private respondent, and
Well, the private respondent is a very poor man, unable to recover the money to the government.
so direction be given to the state respondents to.
When is veto available?
Your Lordship,
We'll list it next week.
Your
In
Lordship.
the presence of veto, we'll pass order.
Yes, Your Lordship.
I think some directions were also issued.
Yes,
To the
some
government
order.
advocate.
Yes,
To the
Your Lordship,
government advocate.
for filing affidavit, Your Lordship.
Affidavit in opposition.
Yes.
No affidavit has been filed.
No, it has been filed.
It has been filed.
It's admitted.
Yes, so let Mr. Vijay
yes, Your
Momi
Lordship.
next week.
Yes,
Yes.
I'll inform him, Your Lordship.
Yes. Listed again on next Tuesday. Where is next Tuesday? Oh, listed again on 4/7/2023. Let us see next week.
Your Lordship.
Much obliged.
For admission, item number 11.
Yes, Mr. What is your case?
Your Lordship, this is a short matter. Matter pertains to transfer of professors.
Transfer of?
Professors. Lecturers.
Transfer of?
Lecturers, Lordship. Under Higher Education Department. Lordship, what happened in the year 2022, that is dated 10/10/2022, the petitioner was transferred from Saojang College to Timor College. That transfer order was issued by way of general reshuffle in the department, Lordship. And as per the transfer order, Lordship, handing and taking over should be completed within 7 days, 10 days, Lordship. However, whatever, Lordship, petitioner was not released from Saojang College, despite the fact that the transfer order was issued on 10/10/2022.
Who did not release the petitioner?
The principal, stating that the higher authorities directed not to release the petition. Well, the matter does such, Your Lordship. Within the period of 1 month, that is on 9/11/2022, the first transfer order was modified, and the petitioner was again transferred to Mont, Tuisang, Lordship, and the private respondent was retained at Dimapur College. Representation was submitted, not considered. Therefore, the petitioner is before this court. Lordship knows the law.
You are before this court to cancel your transfer order?
No, Lordship. There is
Against the transfer order?
subsequent transfer order, Lordship. Because, Lordship, the initial transfer order was modified by the MBO Lord.
Was modified?
Modified by the subsequent transfer order.
Ah.
So I'm aggrieved by the subsequent transfer order.
How?
Because
How are you agreed?
Lordship knows the law. When the initial transfer order which was issued in public interest is modified without giving any reason, it ceases to be in the public interest. The law is very clear. Now in the
You
ambient
mean
transfer,
to say that for modification of the transfer order,
there should be reason.
notice has to be issued to you?
No, there should be reason. Reason should be assigned in the transfer order. Why and how the initial transfer order has been modified.
Not necessarily. Not necessarily.
That is the law, Lordship. I'll satisfy Lordship.
Unless it is modified.
I'll satisfy Lordship.
Okay, let us hear it.
Yes, Lordship. Lordship, we kindly turn to page 18.
Yes. Which page?
Page 18. Annexure B. By this order, Lordship, altogether 28 professors were transferred from different colleges. Lordship. The petitioner name is at serial number 25, next page. Third column, Lordship. Wangkao Government College. She was serving at Wangkao Government College and transferred to Timabo College. Page 19, Lordship. Serial number 25.
From?
From Wangkao Government College, column 3, to Timabo Government College. Column number 5, Lordship. Against Srimati Sunsu Kunyak transfer.
So you want to be in Dimapur?
Yes. That is what the transfer order provides, Lordship. Next, Lordship, 26, serial number 26.
Where's the modification order?
Yes, Lordship.
Where's the modification order?
Page 20, Lordship. 21 is the type copy.
Yes.
Page 21 is the type copy, Lordship. This order dated 9th November 22. The petition name is at serial number 5.
From Wangkao College to
Timabo College, transferred to Saujang College. Serial number 4 is the brave respondent number 4, Lordship. Urgent posting is also wrongly shown. It should be Wangkao College. Timabo Government College, do Wangkao College. Third column remarks, Lordship. Last column, written at Timabo Government College. So initial transfer order was cancelled by this modification order, Lordship. And the petitioner was transferred to Saujang College, and the private respondent number 4 was retained at Timabo Government College.
Four is the private respondent.
Yes.
the order dated 10/10/2022.
Yes, Lordship.
Which serial is the private respondent number
Serial number 26.
26? Yes. What happens? Thereafter?
Lordship, may kindly see the imbued order. That is page 21. No reason, nothing. May I read, Lordship? In continuation to this Roman order, even number dated 10/10/22, that is the first transfer order, Lordship. And in the interest of public service, the Governor of Netherlands placed to order transfer of following associate professors, assistant professors under higher education development. No reason, nothing, Lordship.
Serial number 4 is?
The petitioner? No, Lordship. Respondent number 4.
Serial number 4 is respondent number 4.
Yes. 5 is the petitioner.
What reasons should the government give? What reasons the government should give to transfer you? Is it not sufficient if it is in public interest?
Lordship, that is my case, Lordship. Nothing has been mentioned in the imbued order. And the law is very clear that once the transfer order, which was issued in public interest, is modified, sufficient reason should be given in the transfer order. That is the law holding the field, Lordship. I have 3 authorities
Yes.
in support of my case, Lordship. First, Lordship.
So that is your case?
Yes.
You were actually by order dated 10/10/2022.
Yes, Lordship.
You were transferred to Dimapur. Correct?
Yes, Lordship. And subsequently by order date.
By order dated 9/11/2022. Correct?
Yes.
You were transferred to Southern College.
Yes, Lordship.
And by order dated
9/11.
oh, 9/11. Okay, this is the type copy.
Yes, Lordship.
Type copy. Okay, okay. You were transferred to Southern College.
Yes.
And your case is that actually no reason was cited for while modifying the transfer order.
Lordship.
What is your authority?
Lordship, first 1997, 1 GLT,
1997.
1 GLT,
1
GLT, 140,
GLT
140,
1
140.
140. Para
Lordship, short judgment,
para
2 page only.
entire judgment.
Yes. This case is also from Nagaland, Lordship.
Yes.
Page 141.
Yes.
May I read, Lordship?
Yes.
Heard, Mr. Swinso, learned counsel for the petitioner. Mr. Swinso, learned counsel advocate for the respondent number 1 and 2, and Mr. Swinso, learned counsel for the respondent number 3. In this petition, the petitioner has sailed the imbued order dated 14/2/1996, hosting 3 respondents of the Assistant Commissioner of Texas to the mobile court at Dimapur, in supervision of the previous transfer order dated 5/12/1995. This case has legal history and factual metrics may be briefly stated. By an order dated 17-10-1995, the government of Nagaland finished the royal transfer as many as three officers, including third respondent in public interest. In the aforesaid order, the third respondent Assistant Commissioner of Texas, Dimapur Zone, Dimapur was transferred and posted to Mookchang Zone. This order was modified by order dated 5th December 1995, giving in advance of the transfer of the third respondents to Mookchang. The order dated 5/12/1985, modifying the order dated 17/10/1995, has an important bearing and it is extracted. On partial modification of this government order, even so, in the interest of public service, the governor of Nagaland is pleased to give the advance the transfer of Shri So, Assistant Commissioner of Texas Dimapur, and Shri So, Assistant Commissioner of Texas Dimapur is transferred and posted to Mookchang Zone with immediate effect. The aforesaid order dated 5th December 1995 has been sent by one after evicted government servant in civil law number 0. This court on 12/12/1995 issued a law and suspended the modification order dated 5/12/1995 in terms of the following. This court has held repeatedly that for cancellation, modification, or giving advance of the transfer order, much in public interest must be supported with sufficient reason. From the imbued order dated 5/12/1995, it is clearly appears no reason whatsoever has been assigned necessitating the passing of the modification order. 5. The present imbued order dated 14/2/1996, which has been assumed in this petition, has been passed again in supersession of the order dated 5/12/1995. The imbued order dated 14/2/1996 reads: the governor of Nagaland is placed to order transfer and posting of Shri So, Assistant Commissioner of Texas to the mobile squad at Dimapur with immediate effect. This supersedes the previous transfer order number dated so. From the facts as alluded above, it is clearly shown that within a span of almost 4 months, my case is within 1 month, as many as 3 transfer order has been passed in respect of third respondent without assigning any reason. Therefore, it cannot be said to be in public interest. From the imbued order dated 5th December 1995, which has been sealed in another civil roll number 00 and other order dated 14/2/1996, which is been sealed in this civil rolls, clearly appears that no reason has been assigned necessitating the modification or supersession of the transfer order dated 17/10/1995, was in public interest. Paragraph 8. This court in getting up decision has held that for cancellation, modification, or being in advance of the transfer order passed in public interest must be supported with sufficient reasons, necessitating for passing such order. The view taken by this court has rationale behind it. Once the transfer order is made in public interest, court normally do not interpret unless the order is passed with malafide or against statutory laws. The only way open to the aggrieved government servant is to file representation before the competent authority to retrace his grievances. But this court insists that for cancellation, modification, or giving it evidence of such order must be supported with sufficient reasons. Because transfer of an officer are always made in public interest, and after elaborate exercise as to who should be transferred where and exigencies of administration. While processing the transfer order, various factors are to be taken into consideration. One such factor being the duration of stationing of one officer in a particular station for a long time. If an officer is posted in a particular station for a long time, no doubt that he also acquired a considerable knowledge about the administration of the area, but at the same time, he is also often establishes vested interest in the area because of his long association, and to avoid such eventualities, timely posting is always called for. Therefore, if the transfer order meeting public interest is allowed to be taken away by another graphic order modifying, cancelling, or giving in advance of the transfer order without assigning any reason, it ceases to be in public interest. Therefore, it must be held that the order has been passed at the whims and caprice of the authorities exercising the powers, public interest would not be allowed to be sacrificed at the elder of whims and caprice of the authorities exercising the power. It must be perhaps that the public authorities possess to use public interest. Mr. Benisha Malay Council, appearing for third respondent, at the outset candidate that the basic formation of the issues of the writ of amendment as an infringement of legal rights, and since the petitioner has no legal right to continue in the post of doing so, this writ petition is not maintainable. This question has been answered by this court on 22 to 1996, while suspending the Indian order dated 14 to 1996. Itself, in this writ petition, this court observed that issuance of a roll an interim order would not preclude the competent authority for passing a decision posting of the industry of the petitioner. This apart, this is a specific prayer this petition for quashing the ambient order dated 14 to 1996, that is the modification order, as being arbitrary, illegal, and malified. Under the above circumstances, the condition of Mr. Swinsu cannot be accepted. As already said, the ambient order dated 4/10/12/1996 and Imperial Order dated 5 to 1995, as noted about like reasons, let alone sufficient reason, and therefore it cannot stand the scrutiny of law. The Imperial Order dated 14 to 1996 is accordingly quashed and set aside. And another notion. Another judgment. Two 2013.
You give me some ruling on this Supreme Court. 2013.
Lordship, this type of cases is not been set up as Supreme Court, Lordship.
Why not? Anyhow, what is your next one?
Okay, Lordship, 2013, 5 GLD,
5
GLD,
LT
487.
487.
Please. Paragraph 1, 2, 3, 7th, 17th, 21 and 22.
21 and
22. Yes, Lordship.
Yes.
By this application under Article 26 of the Constitution of India, petitioner has challenged the validity of order dated 11/4/2013 issued by Swiss Government of United Parties. The facts of the case arising from this late petition, the affidavit in opposition, affidavit in reply, the additional affidavit filed by the petitioner and respondent are as follows. The writ petitioner, Su, was originally working as DRCHO at Su, wherefrom he was transferred to WQ as DMO by order dated 7/10/2010. After completion of more than 2 years and a half, he has been ordered to be transferred by order dated 5/4/2013 from Swinsu to Basikat in the East Siam district in the same capacity. By the same order issued by the Commissioner, Health and Family Welfare, Government of Arunachal Pradesh, one Dr. Swinsu has been transferred into the resultant vacancy of DMO at Swinsu. Due to office transfer of the petitioner, the post of DMO at SIPA, unturned, has been ordered to be filled up by one Shri Swinsu, who was the DRCHU. Thus, order dated 5/4/2013 in both five places and transfer of 5 persons. By the said order, the petitioner has been directed to report for joining at Basikat, and the respondent number 3 herein, who is in charge of DMO at that place, has been directed to hand over charges to the regular DMO, namely the petitioner herein. Let me be mentioned herein that the respondent number 3 was originally posted as DRCHU in Basikat itself since 2005, and by order dated 9/8/12, he was posted as in charge DMO at the same place till TBC or posting of regular DMO. This order reveals that respondent number 3 never appointed as a regular DMO at Basikat, where the petitioner has been transferred by order dated 5/4/2013. The lead petitioner was released from Suensu on 9/4/2013, enabling him to join the new police posting at Basikat and Pier Awan. He reported for training to the Deputy Commissioner on Suensu. The said training report appears to have been received by the confidential, confidential assistant to the Deputy Commissioner on the same day. Subsequent communication dated 24/5/13, which I shall refer to later, the Secretary of the Government of Arunachal Pradesh and the Government of Suensu indicates that the Deputy Commissioner, by WD message sent on the same day, had advised the Secretary to ask him joining the petitioner, and thus it is discernible from materials and record that the Commissioner himself was in the active participation of all issues. The petitioner has claimed that having reported for training to the Commissioner being the hit of the civil administration of the Basikat, he conducted respondent number 3 for taking over the charge pursuant to order dated 5/4/2013, but he turned asked the petitioner to wait for some time so that.
Yes, read the principles of law. Read down.
Yes, I'm reading the facts, Lordship.
No, facts different.
Lordship.
Read the principle of law.
Paragraph 3.
Read.
Lordship, paragraph 4. 4 clause 3. Page 489. Paragraph 4 clause 3. May I read, Lordship? Paragraph 4 clause 3. Page 489.
What is the reasoning of the court?
Lordship. Paragraph 21. Page 493. Paragraph 21. May I read, Lordship?
Yes.
The event sufficient force in the submission of the learned person to the petitioner in this case, having issued a transfer order on 5/4/2013 in public interest, the government fell error and modified the same after nearly a week. That too, asking of the extraneous authority to the public interest. It is not conceivable under existing cabinet setup of the executive as how someone who has no responsibility in giving government can both news and the Honorable Chief Minister also obliged to such requests. Above all, secretaries and the commissioner of the government at various departments are well aware about the day-to-day functioning of the respective department. So the view based on the material and records can be at any means be preferred to the personal likes or dislikes of political personalities who, in view of electoral politics, may have been with many compulsions. Besides this court and case of so held that a modification order also has to be reason one. The immune modification order dated 11/4/2013 goes counter to such proposition of law. There is nothing anywhere to hold that the immune order was issued in public interest. Rather, it was passed at a mere asking of some extraneous authorities, and as such, it is not sustainable. So far as the submission of the senior government advocates that the petitioner has acted unharsh in filing the writ petition also does not appear to be able. But the learned senior government advocate has not pointed out as to whether there was any further scope for reconsideration where the Secretary of so has already issued order dated 11/4/2013 to retain the respondent number 3 at Basikat on the basis of so note dated 11/4/2013 referred to above. The representation submitted by the petitioner on 22/4/2013 therefore cannot be accepted to be faithful, and as such filing of the writ petition on so itself, in my opinion, cannot be held as one of the antitrust. And the result, the writ petition is allowed. The order dated 11/4/2013 allowing respondent number 3 to retain at Basikat as demo is satisfied.
Whether there was any political interference in your case?
No, Lordship. And Lordship, by filing affidavit negotiation, the respondent authorities tried to explain how the ambient notification was issued. Some explanation has been given in the affidavit that the transfer was, the modification was made taking into consideration of the health condition of the verbal respondent chair. So by that explanation, the respondent authorities meant to say that the retention of respondent number 4 is on humanitarian ground, and therefore modification humanitarian ground. And therefore the modification order was issued on 9th, 11th, 2022. Lordship knows the case of Winter Singh Lordship. The validity of an order must be reasoned judged by the reason mentioned in the order and cannot be supplemented or added by way of explanation in the affidavit. No reason has been given in the immune order. What compelled the respondent authorities to issue the first modification order, modifying the first transport order? Therefore, Lordship, my submission is justification and explanation given in the affidavit by the authorities, by the respondent authorities, to support the immune modification order, Lordship, is against the law laid down in Mohendra Singh case, Lordship. So, in support of my submission on that issue, Lordship.
So the law is well settled. The law is well settled that the state cannot improve its case by filing affidavits.
I'm referring to another judgment.
Yes. What is that?
Lordship, 2021 5 GLD 652.
There is one celebrated judgment of the Honorable Supreme Court on that issue.
Yes. This is also transfer case, Lordship. Mohendra Singh case is also referred.
It's very clear. It's very clear that actually the government cannot improve its case by filing affidavits when no reason has been cited in the order.
I'm just taking your Lordship to the finding. This is also a transfer case, same case, Lordship. First transfer order was modified without giving any reason. Lordship, 2021 5 GLD 652.
Yes.
Lordship, I'm referring to only two paragraphs. Lordship, paragraph 12. Paragraph 12.
12.
And relevant part, paragraph 12, 12 and 13, Lordship.
12 and
13. 11 bar this lordship, page 656. Last,
Para 12.
yes.
It's a long para. Which portion you want to read?
Lordship, 656 page. Last part on the right hand side, Lordship.
656.
Yes. Last part. The sentence starts from to the whole, Lordship.
Do in the affidavit.
Yes, Lordship. May I read, Lordship?
Yes.
Though in affidavit of association dated 18/11/2020, certain explanations are sought to be given in view of the absence of such justification or even the hint thereof in the ambient order dated 22/9/2020, the same cannot be accepted by this court. The Honorable Supreme Court in Karina decision has settled the law in this regard. Reference to the case of Mohinder Singh, Lordship, so Para 8. The second equally relevant matter is that when a statutory functioner makes an order based on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by reason in the shape of an affidavit or otherwise. Otherwise, an order better in the beginning need by time it comes to the court on the ground of challenge, get validated by additional grounds, later brought up. We may here draw attention to the observation of public orders publicly made in exercise of state authority cannot be constituted in the light of explanation subsequently given by the officers making the order what he meant or what was in his mind or what he intended to do. Public orders made by the public authorities are meant to have public effect and are intended to effect the actions and the conduct of those to whom they are addressed and must be construed objectively with reference to the language used by the court. Last logic, paragraph 30. Even otherwise, as discussed above, the explanation justification both word in paragraph 13 of the affidavit of association appears to be perfunctory and superficial. To Shri So learned senior counsel for the bank may be correct and containing the transfer is an incident of service and the ambient order has been issued for its exigencies. The same has to be tested under standard of Article 14 of the Constitution of India by balancing the fundamental rights of the petitioner to be rated fairly and transparently. Therefore, without even going to the aspect of issue of disability of another, disability of the mother of the petitioner by habits, this regular data so this court is of the view that a case for reference is made out. Accordingly, the writ petition is allowed by setting aside the ambient order dated 22/9/2020, by which the petitioner was sought to be transferred to so. The petitioner may be accordingly be allowed to continue with so or to be posted to so. This court is further of the opinion that since the recognition of the petitioner that is so was already favorably considered. In case the bank is unable to transfer the petitioner to either of the two locations, namely so and so if the CC so desires transfer and post the petitioner to any post in or near Gauhati, considering the element of the age of the petition. So in this case also, the still respondents try to explain, defend the ambient petition order by giving me explanation, and this court.
Please bring your mic.
Lordship, sorry. So by filing affidavit of association, Lordship, the respondents have given explanation that the revision of the respondent number 5, respondent number 4 is in humanitarian ground. Because as per the affidavit, Lordship, the child of respondent number 5, the respondent number 4 is not feeling well. Therefore, Lordship, my case is such an explanation cannot improve the case of the respondent authorities because no reason has been given in the ambient order. What compelled the respondent authorities to modify the initial transfer order issued in public interest? Lordship, may kindly turn to government affidavits. The explanation given by the state respondents. Lordship. Respondent number 1, 2, and 3. Paragraph 5.
Yes.
Mayor Lordship.
Yes.
That with regard to the developments made in paragraph 6 of the writ petition, the answering respondents state hearing
You are
that
reading paragraph?
paragraph 5
Fine.
of the affidavit notification filed by 1, 2, and 3.
Paragraph 1, 2, and 3.
Yes.
Yes, that with regard,
To the state agreement made in paragraph 6.
that with regard to the,
Agreement made in paragraph 6.
no.
Affidavit of association on behalf of respondent number 1, 2, and 3.
Oh. Yes. Yes. Yes, yes. Yes.
May I read, Lordship?
Yes, please.
That with regard to the agreements made in paragraph 6 of the writ petition, the answering respondents state herein that initial transfer order dated 10/10/2022 was modified. That is their statement by another order dated 9/11/22 in respect of 9 officers. And in respect of respondent number 4, the answering respondent received a forwarding letter from the principal, Dimabur Government College, Dimabur on 4/10/2022 for retention of service of respondent number 4 in Dimabur Government College, Dimabur on humanitarian ground. The authorities accordingly examined the medical report submitted by respondent number 4 in respect of her child, and it was found to be genuine as her child, age about 3 years old, is a patient of so, who is in constant need of medical supervision and care, which is available only in Dimabur. As such, answering respondent considered the request of respondent number 4 and retained her at Dimabur Government College on humanitarian ground, taking into consideration of the office memorandum dated 8/10/2018, which provides that exemption from the routine exercise of transfer, rotation transfer, that as per para 3, clause 3, the term specified disability as defined herein is applicable as a ground only for the purpose of seeking exemption from the routine transfer, rotational transfer by the government employees who is and caregiver of dependent daughter, son, parents, spouse, brothers, sisters, as stated para 3, clause 1. So that is the explanation given by the state respondents. And paragraph 8.
Para 6.
Para 8. That with regard to the developments made in para 10 of the writ petition, this development beg to state that the modified order dated 9/11/22 was initiated on humanitarian ground and for welfare of the public servant, but denied the allegations stated by the petitioner. Now, Lordship,
Yes.
I've referred to the judgment passed by this rebel court as regard the modification of the first transfer order, which was issued in public interest, Lordship. And secondly, Lordship, as per the judgment which I've just referred to, Your Lordship. The modification order, in the modification order, Lordship, the reason should be given. But here in my case, Lordship, no reason, nothing is mentioned in the subsequent modification order. Reason for retention of respondent 4, as well as subsequent transfer of the petitioner to Saujang College. No reason, nothing, Lordship. Therefore, Lordship,
Whether this office memorandum by 8/10/2018 is enclosed. It's enclosed.
yes, Lordship.
Okay, fine. Yes, continue.
So, Lordship, my submission is the impugned modification order dated 9/11/2022 cannot be improved by way of explanation given in the affidavit, because no reason has been assigned in the impugned order for detention of respondent number 4 at Dimapur Government College and the subsequent transfer of the petitioner to Saujang College, Mon. And the present case is, Lordship, squarely covered by the judgment which I have referred to, Lordship.
Yes.
So my prayers is, Lordship, to sit aside and quash the impugned modification order dated 9/11/22.
When you make the submission that the government cannot improve its case by
Yes.
filing affidavit,
Sure, Lordship.
do you also mean to deny that the child of the respondent number 6 is sick, requiring the constant attention of the respondent number 4?
I don't have any submission on that.
Yes.
Therefore, Lordship, my only submission is that the impugned order by which the original transfer order was modified is against the law laid down by this honorable court, as well as the principle of law laid down in Mohinder Singh case. Therefore, my prayer is to set aside and quash the impugned modified transport order and let the authority initiate transfer and posting in terms of the first initial, Lordship, first transfer order, that is 10/10/2022.
Is there a stay order?
Lordship.
Yes.
I conclude my submissions. Obviously.
Yes, Governor.
Yes, bless your lordship. Uh, your lordship, your lordship is well aware, uh, well aware of the settled principle in service jurisprudence that transfer is incidental to employment. The settled principle of law and the service jurisprudence that transfer is incidental to employment. And the transfer in posting of an employee by the employer is the prerogative of the employer. The employers know the best place where and the employee has to be posted. So, your lordship, my very foundational objection is that where is the enforceable rights of the petitioner has been violated in this petition? That is my first question, number one, your lordship. Well, and can any of the case, decided cases made by the Honorable Apex Court, it is made very clear that the transfer in posting is incidental to the employment. And your lordship, the first order of transfer in posting and the second modification of transfer in posting was issued following the due process of law, following the roles of the executive business in Nagaland, as amended at the date, by the authority in the hand of the governor. So my only question is that roles of the executive business.
You are referring to that rules. Which rule? Which is the relevant rule?
No, relevant role, lordship.
I know the rules of executive business. Which rule?
I don't have the book, but
That's what come with that. You're not supposed to make this kind of submission. You're a senior governor today. You assist the court with your submission. Then you are actually relying your submission on one rule.
because role says roles of the executive business in Nagaland has been enacted as per the Article 166 of the Constitution. Role says that all the executive business of the state has to be carried out as in the name of the governor. In the name of the governor. So your lordship, this exercises.
If you are relying to a rule, let us come clear. I'm clear with the rules. Not just make some submissions somewhere.
No, lordship, what I'm saying is that this exercises has been made. The notification as well as the first order was made in consonance with the roles of the executive business.
I know the rules of executive business. It is framed under Article 166. But which is the rule? Which is the relevant rule? Which empowers the government to effect transfer of its servants? Yes, when you are making a
No, lordship.
relying on the rule, at least you should be able to substantiate. Not just
No, lordship, what I'm saying is how we have made the transfer. Because we have made the transfer in posting on the basis of that rule. This is what I'm saying. And coming to the point, your lordship,
you are relying
coming to
on
the
submission
facts.
on the rules of executive business. You are relying on submission of the rules of executive business.
No.
That's why I'm asking you, which rules?
Your
And
lordship-
you should come prepared.
Your lordship,
With all those materials.
your lordship, I'm not relying on that.
You cannot come casually. The government is watching you. There is
Your-
live streaming.
Your lordship, I'm not relying on that. And what basis we have exercised the transfer in posting? That is what I'm saying. I'm not coming to the facts, your lordship. Facts, I'll come.
Are you understanding your own submission? OIMC? Are you understanding what submissions you are making and what queries the court is raising?
Lord, why, what, Your Lordship, please listen to me, Lord.
I am listening. That's why I'm asking you questions after having heard you. I'm asking questions
Lordship.
after having heard you.
Lordship,
Not out of the
I'm just bringing before you, Your Lordship, saying that exercise of transport has been made by the state and exercise of the bars conferred under the rules of executive business, as amended at the date. I'm not coming to the facts.
provision. This court, in precise, this court is asking you under which provision of the rules. You are making a submission relying on the rules of the executive business.
Lordship, I'll come to the
cannot
facts.
Just for example, you cannot just say that the crime was committed under IPC. You cannot say that. You have to actually satisfy this court under which provision of IPC the crime was committed. What is the crime referred to under the provisions of IPC? You cannot just say that the crime was committed under IPC.
Lordship, in that aspect,
Referring to a rule of executive business.
Lordship, in that aspect of the matter, if your Lordship don't agree, then I tender my apology.
Making submission, you be careful. The government is watching you. There is live streaming. We have told the government to watch the submissions of your lawyers.
Lordship, may I come to the facts?
Yes.
Lordship, may kindly turn to page 3, paragraph 14 of the state contract. Paragraph 4, Your Lordship. Paragraph 4, page 3. May I read it, Your Lordship? That with regard to the amendments made in paragraph 4 and 5 of the read petition are admitted to the extent that a general refusal in the department has been initiated by transfer order dated 10/10/2022. It is the general rule and practice that for a government servant during the course of transfer, the release order has to be issued by the authority and the relevant to join the vacated post. However, it appears that the petitioner initiated shifting to the transferred place before receiving the release order from the authority. Lordship, paragraph 5, that with regard to the amendments made in paragraph 6 of the read petition, the answering respondent herein state that the initial transfer order 10/10/2022 was modified by another order 9/11/22. Lordship, this is under challenge. And let's pick up 9 officers, Your Lordship, not only to the petitioner. And let's pick up respondent number 4. The answering respondent received a forwarding letter from the principal of Dimapur Government College, Dimapur, on 14/10/2022 for retention of service of the respondent number 4 and Dimapur Government College on humanitarian grounds. The authorities accordingly examined the medical report submitted by respondent number 4 in respect of her child, and it was found to be genuine, as her age, about 3 years old, is a patient of Down syndrome and congenital heart defect. Medical science is called arterial septal defect, who is in constant need of medical supervision and care, which is available only in Dimapur, Your Lordship, which is available only in Dimapur. As such, the answering respondents considered the request of the respondent number 4 and retain her service at Dimapur Government College on humanitarian ground, taking into consideration of the office memorandum dated 18/10/2018. Your Lordship, you'll find the office memorandum and page 13, Annexure C, Your Lordship. 13, Annexure C. Lordship,
Annexure C.
Annexure C, page
There
13.
is no paging of your annexures.
Annexure C, Your Lordship.
There is no paging. You make a paging. Yes, Mr. Mohan. You make the paging in your affidavit.
Regular.
Yes, Mr. Mohan.
Yes, Your Lordship. This is Office Memorandum, Government of India, Ministry of Personnel, Public Grievances and Pensions, Department of Personnel and Training. 8 October. May I read it, Your Lordship?
Yes, please, yes.
Office Memorandum, Your Lordship. Subject, exemption from the written exercise of transfer slash rotational transfer. Considering that the transfer of a government employee who serves as the main caregiver of persons, Your Lordship, caregiver of persons with disability would have a bearing on the systematic rehabilitation of persons with disabilities. The government issued OM, even number dated 6 June 6, 2014, to exempt such employee from routine exercise of transfer slash rotational transfer subject to administrative constraints. Number two, the scope of this disability initially has covered number one, blindness or low vision, number two, hearing impairment, number three, locomotor disability or cerebral palsy, number four, leprosy cure, number five, mental retardation, number six, mental illness, and number seven, multiple disabilities, which subsequently by OMs of even number dated 17 number November 2017, 2014, and January 5, 2016 was further extended to include autism, dyslesia, and hemophilia. Number three, with the enactment of the Rights of Persons with Disabilities Act 2016 on April 17, 2017, the following instructions are issued in suppression of the above mentioned OMs of event number dated 6 June 2014, November 7, 2014, January 5, 2016, with regard to the eligibility for seeking exemption from routine exercise of transfer slash rotational transfer. Number one, a common employee who is a caregiver of a dependent daughter slash son slash parents, spouse, brother, sister with specified disability as certified by the certifying authority as a person with benchmark disability as defined under Section 2R of the Rights of Persons with Disabilities Act and 2016 will be exempted from the routine exercise of transfer, rotational transfer subject to administrative constraints. Number two, the term specified disability as defined in the Schedule to the Rights of Persons with Disabilities Act 2016 covers so and so, Your Lordship. There is repetition only, Your Lordship. Lordship, kindly turn to the next page. So, Your Lordship, the department, the state has considered this OM and
So, Mr. Moore,
yes,
Mr. Moore,
yes,
the medical of the child of the respondent number 4 has been submitted,
yes.
the medical reports.
Medical reports are also there.
So, under which specified disability the child of the respondent number 4 will fall? As per the medical.
These are, Your
Whether the
Lordship,
government has examined them.
Lordship, these are specialized terms.
That's why.
But,
That's why.
but if the Lordship could
Since
see,
you are actually giving exemption to the respondent number 4 in terms of the OM dated 8/10/2018, which also talks about specialized, specified disability, which class of specified disability the child of the respondent number 4 falls?
Your Lordship, Para 2.
Para 2 of the OM.
Yes, Para 2 of the OM, Roman 7.
Para 2 of the OM,
Roman 7.
7, intellectual.
No. Roman 7 is multiple disabilities, Your Lordship. Page 14.
Just which page? Page 14?
Page 14.
Page 14?
Para 2.
Para 2. Okay.
Roman 7.
Multiple disability. This one.
This is what, because these are specialized terms. Because the Lordship kindly come to page 9.
Page 9.
Page 9. Page 9.
Yes. Page 9. Yes, please.
Here, prayer for retention. There is a representation by the private respondent, Your Lordship. So, Your Lordship,
This is by the private respondent.
it,
A condition called Down syndrome.
Down sent him, and then he has a congenital here. He also had a congenital heart defect. This is called arterial septal defect in medical terms.
Can you file a proper affidavit? We'll keep it as moderate. Can you give it file a proper affidavit on this office memorandum and the sickness of the child?
Yes.
Can you file a proper affidavit? Because
I have to consult the specialized.
Yes, that's
Yeah,
why.
yes.
You have that means and resource at your disposal to actually satisfy this code as to which specified disability the child of the respondent number 4
Correct,
is.
correct.
Those actually, that is your main case.
Yes.
Correct?
My only, your,
Mr.
the,
Moy Jamir. Mr. Double Moy. Can you assess this code on this issue?
Your Lordship is not a doctor.
No, you're for private respondent.
Yes, Lordship, I'm representing the private respondent, Lordship.
Just for the clarification of this code, the government has brought up this office memorandum
Yes, Lordship.
under which there are certain there are actually the guidelines for exemption
Exactly,
on
Lordship.
medical grounds.
Lordship.
Now, the as per the affidavit of the government, the respondent suppose a transfer from Dimapur has been retained
Lordship,
on account of sickness of the doctor of respondent.
Lordship,
Now here, they have actually like, we don't know, we are not, don't actually not in medical terms.
Lordship,
But this court wants to know whether the sickness suffered by the son,
Lordship,
is it son?
Lordship,
Son of the respondent number 4 falls within the sickness specified in the office memorandum dated 8/10/2008.
Lordship,
This court wants to,
Lordship.
so that I have a very clear picture of it.
Yes, Lord. Lordship, as rightly pointed out, it will be competent on the government to file an affidavit saying that they have applied a mind and they came to a decision upon which this subsequent transfer order was.
That is
Lordship.
okay. That
Yes,
is
Lordship.
okay. I am on the technical aspect.
Yes, Lordship.
I am on this technical aspect.
Lordship.
So I want the government to actually, I want to see that the government files an affidavit as to which of the sickness referred in the office memorandum dated 8/10/2018. The sickness of the child of the respondent number 4 falls.
Yes, Lordship. An additional affidavit will suffice the explanation,
Mr.
Lordship.
Moore, yes, Mr. Moore. I think you are the institution who has all the resource to come up with this explanation.
Yes.
You actually give a clear affidavit.
Yes.
You say that the son of the respondent number 4 is ill. Correct?
Yes.
Is ill. And therefore, as per the government affidavit, as per the government office memorandum dated 8/10/2018,
Yes.
he was retained in Dimapur.
Yes.
Now, this court wants to know whether the sickness suffered by the son of the respondent number 4 falls within the sickness specified in the office memorandum dated 8/10/2008. So you will have to properly read your page 9.
Your Lordship.
Your page 9.
Your
That
Lordship.
is the representation submitted by the respondent number 4.
Your
And
Lordship.
you have to also properly read the office memorandum dated 8/10/2018.
Yes.
Okay? To actually satisfy, to show this court that the sickness of the respondent number 4, son of the respondent number 4, falls within the sickness specified in the office memorandum dated 8/10/2018. Yes, we'll keep it partnered. We'll keep it partnered. We'll allow the government to file a.
Yes, since Lordship is giving this matter by third, I have a prayer, Lordship. Since they brought that office memorandum and the other grounds to justify the ambient modification order,
Yes.
Lordship may kindly call for the records whether they have actually considered this aspect so as to ascertain the decision making.
Lordship, even otherwise, sorry for indulgence, Lordship. I have a decision rendered by the Honorable Gauhati High Court in a case, and a similar case, Lordship, that even the medical term, Lordship, the Down syndrome, it was also discussed in this case, and even the same office memorandum has been discussed, Lordship. It has observed that the medical term, Lordship, the medical disability, Lordship, it falls under the office memorandum 2018, Lordship. And in addition to that, Lordship, some legal principles, general principles has also been discussed, Lordship. 2021. It was decided on 6th of July, 2021, Lordship. Relevant paragraph starts from paragraph 8, Lordship.
Okay, I will read.
Lordship.
If this citation covers the inquiry sought by this court, then we will continue.
Lordship.
Okay, Mr. Moore. Yes, Mr. Moore.
Yes, Your Lordship.
Yes.
Yes, Your Lordship. So we have considered the representation
submitted by the private respondent number 4, which is in page 9, and on consideration of that, so on consideration, of the private respondent's representation, and as per the which memorandum dated 8 October 2018, we have retained the private respondent. Because the challenge is that notification order was, Your Lordship, for nine persons, but the present challenge is coming for respondent number 4 only. So in regard to respondent number 4, we have made a decision on the basis of that, those relevant things, Your Lordship. So, Your Lordship, that is my submission, Your Lordship. So, Your Lordship, my humble submission is that the present petition is devoid of merit, so it has to be dismissed, Your Lordship.
On the grounds raised by the learned counsel for the petitioner, that after issuing the first transfer order,
Your Lordship.
no reason was cited to issue the second transfer order. What is your submission on that?
Lordship, my submission is in that how can I,
Because that is the main grounds taken by the petitioner, that actually after issuance of the first transfer order, while actually doing away with the first transfer order and coming out with the second transfer order, no grounds were cited, no reasons were cited. That is basically the case of the petitioner, right? Yes. So what I have to submit on that?
Lordship, that two reasons only that I have given, that we just studied the office memorandum in other thing, and so far as the private respondent has been concerned. Your Lordship, because it's a normal transfer, so if it is a way of punishment, then reason has to be given. And normal transfer, normally reasons are not given, Your Lordship.
Yes. The normal transfer reasons are not given.
Yes.
But there is a question where actually there is modification of the transfer order. And the learned counsel for the petitioner says that for modification, he is not arguing on the first transfer order. And normally the first transfer order, no reasons need to be given. It is sufficient if the transfer order is issued in public interest.
Your Lordship.
But here is a question where actually the first transfer order has been modified. And the learned counsel for the petitioner submits that there is no reason given for the modification. So yes, submit.
Your Lordship, where is the malafide? Your Lordship. Petitioner has to make out the malafide. Malafide. Where is the malafide, Your Lordship?
Yes.
Because certain things has to be changed, so we will modify that. Status modify that, Your Lordship. That's all. Your Lordship.
That's simple. Simple.
Because petitioner has not made out the malafidness. If there is a malafidness, then this honorable court can interfere with it without any malafide. Malafide intention has to be there. It is not there, Your Lordship. Published, Lordship.
There are no submission, no citations. No citations for the government because this is your case. You have to come prepared with citations and all. You have no citation. So many citations
Your Lordship, this case can be dismissed on facts.
No. It is not as easy as you think. How can this court say that actually like the first transfer order against the first transfer order, there was a modified transfer order. The petitioner has not shown any grounds of modified and therefore this petition is dismissed. How can this court come to that?
published, Your Lordship.
May it please, Lordship. Lordship, I'm representing the respondent number 4, the private respondent, Lordship. 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 4, Lordship. Respondent.
Yes.
Lordship, the petitioner's cases. The arguments made in paragraph 8, 9, and 10. There are only 3 grounds, Lordship. 8 says about there was no reason specified in the modifying order. Paragraph 9 of the writ petition says about malified intention of the authorities, Lordship. Para 10 of the writ petition. Specific averment was made that the subsequent transfer order was issued at the behest of the respondent number 4. That is these are the 3 contentions raised by the petitioners in the petition, Lordship. I'll be more on the question of law, Lordship, since all the facts has been discussed, and also while the state government has filed the affidavit, they have produced my representation, Lordship, on which representation the government has applied a judicious mind, and the subsequent modifying order dated 9/11/2022 was issued, Lordship. I have also specifically mentioned in my representation about the medical conditions of the child, Lordship. Now, basing on the medical condition, the subsequent order was issued. This is an exceptional case, Lordship, where the authorities relied upon by the petitioner is not relevant in this case. That is my humble submission, Lordship. Now, Lordship, coming to my contentions, Lordship, I'm raising on 4 grounds, Lordship.
Yes.
4 grounds, Lordship. The first is, it is a settled principle of law that court should not interfere with transfers until and unless it is proved that the transfer order is made in violation of mandatory statutory rules or there is a malified intention. These are the 2 exemptions, Lordship. So the petitioner's case, the petitioner has to make his case that there was violation of statutory mandatory rule or malified intention, Lordship. And not merely making an averment that there was malified intention, that will not suffice malified intention, Lordship. Second, Lordship, even in the case of the petitioner as well as the private respondent, transfer is an incident of service, Lordship. I accept that, Lordship. It is an incident of service. And we are at the disposal of the common servants are at the disposal of the employer, Lordship. So this is purely an incident of service. Thirdly, I'll be relying on the definition of malified as defined by the Honorable Apex Court and several authorities, Lordship. Definition of malified intention, Lordship. Fourth is, Lordship, this is a very exceptional case where the order has been affected, the modifying order, as well as the initial order has been affected on medical grounds, Lordship. The 2 orders, these are general orders, Lordship. And it has been specifically mentioned that the order is issued in the public interest, Lordship. Public interest has been already mentioned, Lordship. Now, what the law says when the public interest is mentioned in the transfer orders, Lordship, I'll be relying on those authorities, Lordship. If I may be allowed to rely on the first. 1991 Supply, Volume 2, SSC 459, Lordship. 91 Supply, Volume 2, SSC, page 659, Lordship. 59, Lordship. relevant para 3 and para 4, Lordship. Para 4, Lordship. Public interest and administrative reasons, Lordship. If the transfer order is issued in public interest and administrative reasons, Lordship, or court should not normally interfere with the transfer. 3 and 4, Lordship. If a Lordship got para 3, Lordship. Para 3. After hearing the learned counsel for the parties and having considered the facts and circumstances of the case, we are of the opinion that the High Court committed serious error in interfering with the transfer orders of primary school teachers. The High Court held that District Education Establishment Committee had no jurisdiction to transfer the primary school teachers on their request. We find no justification for this conclusion. There is no dispute that the District Education Establishment Committee is competent to transfer primary school teachers from one place to other, but merely because such transfers were made on the request of teachers, the committee is not divested of its jurisdiction. The director of the primary education had issued directions that lady teachers posted in distant areas of rural areas may be accommodated to the place of their request to avoid hardship to them. The respondents challenged the validity of the transfers before the High Court on another ground also, that primary school teachers posted in the urban areas were not liable to be transferred to rural areas, though the state government had issued circular on March so-and-so, permitting transfers from urban areas to rural areas. The High Court did not interfere with the order of transfer on this ground. Instead, it held that the transfer orders were without jurisdiction, as the same had been made on the appellant's request with a view to accommodate them. We fail to appreciate the reasoning recorded by the High Court, Lordship. If the competent authority issued the transfer orders with a view to accommodate a public servant, this is important, Lordship, to avoid hardship. This applies in my case, Lordship. I have expressed my hardship before the competent authority, Lordship. The same cannot and should not be interfered by the court merely because the transfer orders were passed on the request of the employees concerned. I have made a request, and that was effective to Lordship. The respondents have continued to be posted at their respective places for the last several years. They have no vested right to remain posted at one place. I agree, Lordship. Since they hold transferable posts, they are liable to be transferred from one place to another. The transfer orders had been issued by the competent authority, which did not violate any mandatory rule. This is important, Lordship. Therefore, the High Court had no jurisdiction to interfere with the transfer orders. The petitioners has failed to make out a case that mandatory statutory rule has been violated in this present case, Lordship. Para 4, in our opinion, the court should not interfere with the transfer order which is made in public interest. And this present case, Lordship, both the orders were made in public interest and for administrative reasons, unless the transfer orders are made in violation of any mandatory statutory rule on the ground of mala fight, Lordship. These are the two grounds where this honorable court can interfere with the transfer orders, Lordship. However, the present orders were made in public interest and administrative reasons, and there is no reasons or there is no evidence to make out a case that there is violation of mandatory rule or malified intention, Lordship. A government servant holding a transferable post has no vested interest to remain posted at one place or the other. He is liable to be transferred from one place to the other. Transfer orders issued by the competent authority do not violate any of his legal rights. Even if a transfer order is passed in violation of executive instructions or orders, this is also important, Lordship, the courts ordinarily should not interfere with the order. Instead, affected parties should approach the higher authorities in the department. If the courts continue to interfere with day-to-day transfer orders issued by the government and its subordinate authorities, there will be complete chaos in the administration, which would not be conducive to public interest. The High Court overlooked these aspects in interfering with the transfer order. This quietly covers my case, Lordship. I agree the fact that I cannot remain posted at one place, but I have expressed my hardship, Lordship. And my hardships are very genuine, Lordship. It is supported by documents, records, Lordship. Lordship, it's nearly 6 to 7 years, Lordship. And my child, Lordship, he's in such an age where he needs care and attention on daily basis, Lordship. I need proper medical facilities, Lordship. And Lordship, may kindly appreciate Mon Town, Lordship, with due respect, they don't have all those facilities, Lordship. Dimapur is the only city, it's the only place in Nagaland where I can get those nearest medical facilities, Lordship. My child is suffering from Down syndrome, Lordship, and also other mental issues, Lordship. He is in a very sensitive age, Lordship, where a constant care and support is required at the moment, Lordship. It is not a case that I want permanent posting at Dimapur, Lordship, but for the time being, Lordship. At this age, Lordship, he's just 3 years of age, Lordship. It is not a case that I want permanent posting at Dimapur, Lordship. I'm ready to abide by any instructions or orders in the near future, Lordship. If I may be allowed to refer to another authority, Lordship. 2009, Volume 15, SSC, page 178. 2009, Volume 15, SSC, page 178. 9, Volume 15, SCC, 178, Lordship. Paragraphs 8, 9, 10, Lordship. 8, 9, 10, Lordship. Lordship will find at page 180, Lordship. The relevant paragraphs 180. If your Lordship's got it. Paragraph 8, Lordship. A government servant has no vested right to remain posted at a place of his choice, or can be insist that he must be posted at one place or the other. He is liable to be transferred in the administrative exigencies from one place to the other. Transfer of an employee is not only an incident inherent in terms of appointment, but also implicit as an essential condition of service in the absence of any specific indication to the contrary. No government can function if the government servant insists that once appointed or posted in a particular place or position, he should continue in such place or position as long as he desires. Para 9, Lordship. The courts are always reluctant in interfering with the transfer of an employee unless such transfer is vitiated by violation of some statutory provisions or suffers from malafide, Lordship. This is very important. And it has also quoted the judgment in Shilpi Post case, Lordship, para 4. In our opinion, the court should not interfere with a transfer order which is made in public interest and for administrative reasons unless the transfer orders are made in violation of any mandatory statutory rule or on the ground of malafide. A government servant holding a transferable post has no vested right to claim posted at one place or the other. He is liable to be transferred from one place to the other. Transfer orders issued by the competent authority do not violate any of his legal rights. This is very important, Lordship. And this modifying order has not violated his legal right, Lordship. Even if a transfer order is passed in violation of executive instructions or orders, the courts ordinarily should not interfere with their order. Instead, affected parties should approach the higher authorities in the department. If the courts continue to interfere with day-to-day transfer orders issued by the government and its subordinate authorities, there will be complete chaos in the administration, which would not be conducive to public interest. Para 10, Lordship. Relevant para 6, it has quoted 6, the scope of judicial review in matters of transfer of a government servant to an equivalent post without any adverse consequence on the service or career prospect is very limited, being confined only to the grounds of malafide and violation of any specific provision. Interference is only limited to malafide and violation of statutory rules, Lordship. The petitioner has failed to make out a case that there is malafide intention. There is violation of rules, Lordship. Nothing as such, Lordship. There's not even a single whisper in the petition, Lordship, that there is violation of statutory rules. And merely making an averment that there is a malified intention, that will not suffice, Lordship. Lordship, these are only the two grounds where this court can interfere, Lordship. And that orders, the modifying order has been issued in public interest, Lordship. For administrative reasons, Lordship. Public interest has been specifically mentioned in the modifying order, Lordship. And if it is very clear, Lordship, the two authorities have relied upon. If the transfer order is issued in public interest, no interference, Lordship, unless malified intention or violation of statutory rules. And this is a very good, clear case, crystal clear case, where the orders has been issued in public interest, Lordship. Yes, Lordship. Lordship. 9 November 2022, Lordship. Page 20, Lordship. Type copy, Lordship, will find it, page 21 of the read petition, Lordship. Page 20, Lordship. Page 20. Type copy, Lordship, will find it, page 21, Lordship. If your Lordship got it. Page 21, Lordship. May I read it, Lordship? This is in continuation of this department's order of even number dated 10/10/22 and intended of public service, Lordship. The governor of Nagaland is pleased to order transfer of the following associate professor, assistant professor under higher education department. Now, Lordship, coming to the malified, Lordship. The petitioner is silent on the violation of any mandatory statutory rule. Only at paragraph 9, Lordship will find that they have mentioned about malified intention. Now, what the law says of malified intention, Lordship? Lordship, it has to be proved. Lordship, I'll take your Lordship to the definition first, Lordship. 1992, Supply 1, SSC. 1992, Supply, Lordship. Volume 1, SSC, page 222, Lordship, 222. Paragraph 50-51, Lordship. Lordship will find the relevant paragraph at page 260. May I read it, Lordship? Paragraph 50. Malified means want of good faith, personal bias, grudged, oblique, or improper motive or ulterior purpose. This is the definition, Lordship. The administrative action must be said to be done in good faith. It is in fact done honestly, whether it is done negligently or not. An act done honestly is deemed to have been done in good faith. An administrative authority must therefore act in a bona fide manner and should not act for an improper motive or ulterior purposes or contrary to the requirements of the statute or the basis of the circumstances contemplated by law or improperly exercise discretion to achieve some ulterior purpose. The determination of a plea of malified involves two questions, namely, one, whether there is a personal bias or an oblique motive. This is the first element. Second, whether the administrative action is contrary to the objects, requirements, and conditions of a valid exercise of administrative power. It is not just merely making an allegation that there is malified intention. These two questions has to be fulfilled, Lordship. On personal bias. Second, Lordship, contrary to objects, requirements, and condition of a valid exercise of administrative power. The petitioner is completely silent on this. Paragraph 51, Lordship. The action taken must therefore be proved to have been made malified for such considerations. Mere assertion or a vague or bold statement is not sufficient. It must be demonstrated either by admitted or proof facts and circumstances obtainable in a given case. If it is established that the action has been taken malified for any such considerations or by fraud on power or colorable exercise of power, it cannot be allowed to stand. This is very clear, Lordship. The petitioner has to overcome and satisfy this honorable court, Lordship, on these conditions. Lordship, the next authority, Lordship. On malified, Lordship. On malified, Lordship. Whether it can be entertained or no, Lordship. 2000, Volume 5, SCC, page 630, Lordship. 2000, Volume 5, SSC 630, Lordship. Paragraph 13, 13, Lordship. Lordship will find it page 639. Lordship. Lordship, as noted above, the High Court has not highlighted this aspect of the matter. Though the same was brought to the notice of the High Court, we do not know for what reasons, neither do we intend to delve into it. But the fact remains that the comment of the learned advocate appearing for the board during the course of hearing before this court that the litigious spirit of the petitioner has, in fact, brought into effect the exercise of jurisdiction of the writ court to a nutritious extent. We do not find some justification in the criticism of the learned advocate for the board vis-a-vis the conduct of the appellant petitioner hearing. The petitioner has been, as noted above, from so-and-so onwards, engaged himself in the law court rather than exerting himself in an effort to improve his capability as the employee of the board so that the board and the state obtain maximum benefit from all of the services of the appellant petitioner. But unfortunately, his litigious spirit prevailed upon him, and as noticed above, we do not find some justification as regards to comment made by the learned advocate appearing for the board. Malifieds have been alleged against the statutory board, but the contextual facts negate such an allegation. Incidentally, be it noted that the expression malified is not meaningless jargon, and it has its proper connotation. Malice or malified can only be appreciated from the records of the case, in the facts of each case. There cannot possibly be any set guidelines in regard to the proof of malifieds. Malifieds, where it is alleged, depends upon its own facts and circumstances. We observe ourselves feel it expedient to record that the petitioner has become more of a liability than an asset. And in the event of there being such a situation, vis-a-vis an employee, the employer will be within his liberty to take appropriate steps, including the cessation of relationship between the employer and the employee. The service conditions of the board's employees also provide for voluntary retirement. A person of the nature of the petitioner, as more fully detailed here and before, cannot possibly be given any redress against the order of the board for voluntary retirement. There must be factual support pertaining to the allegations of malifieds. Unfortunately, there is none. Mere use of the word malified by the petitioner would not by itself make the petition interdignable, Lordship. In this case, there is only an averment in paragraph 9, and that is only an averment that there is malified intention. No records whatsoever, Lordship. Lordship, why this honorable court should not interfere this present petition, Lordship. 2001 SSC, 2001 8 SSC 574. (2001) 8 SCC. This is also malified, Lordship. why the court should not interfere or entertain petitions, Lordship. 1-8 SSC 574, Lordship. 5, Lordship. Only paragraph 5, Lordship. I'll read only the half of the paragraph, Lordship. Para 5, page 577, Lordship. On a careful consideration of the submissions of the learned counsel on either side and the relevant rules to which our attention has been invited to, we are of the view that the High Court was not justified in interfering with the impugned orders of transfer. It is now well settled and often reiterated by this court that no government servant or employee of a public undertaking has any legal right to be posted forever at one particular place, since transfer of a particular employee appointed to the class or category of transferable post from one place to another is not only an incident, but a condition of service necessary to in public interest and efficiency in public administration. Now, Lordship, unless an order of transfer is shown to be an outcome of malified exercise of power or stated to be in violation of statutory provisions prohibiting any such transfer, the courts or tribunals cannot interfere with such orders as a matter of routine, as though they are the appellate authorities, substituting their own decision for that of the management, as against such orders passed in the interest of administrative exigencies of the service concerned. Lordship, next is on the personal difficulties, Lordship. This will be my final ground, Lordship. Difficulties, the medical condition that I've expressed, Lordship. 1993, 1 SSC, page 148. Paragraph 7, Lordship. Lordship will, yes, Lordship. Citation is 1993, 1 SSC, 148. 7, Lordship. Para 7. Lordship will find para 7 at page 153. May I read only that specific sentence, Lordship? It starts from 12th line of para 7, Lordship. 12th line of para 7, Lordship. In a transferable post, Lordship. Or, Lordship, may I start from unless such order, Lordship? Unless such orders pass malified or in violation of the rules of service and guidelines for transfer without any proper justification, the court and the tribunal should not interfere with the order of transfer. In a transferable post, an order of transfer is a normal consequence, and personal difficulties, this is important, Lordship, are matters of consideration of the department. Public interest as well as the personal difficulties has to be taken into consideration by the authorities. That was the observation of the Honorable Apex Court, Lordship. Lordship, the next citation is on, Lordship, the medical conditions, Lordship. If I may be allowed to rely on the No, Lordship, a different judgment, Lordship. By the principal seat of this Honorable Court, Lordship. 2019 SSC online.
2021 SSC online, Guwahati 1309,
Yeah, yes, Lordship. I may be, Lordship, I'll rely on that, Lordship.
the one which you had placed.
Yes, Lordship. Lordship, there is also another Lordship, SSC online. That is, one is
You are relying on which? 2019 or 2020?
both, Lordship, both, Lordship.
So now which? So now you are relying 2019?
Lordship, 2019. Lordship.
This Dr. Nitramuni.
Yes, Lordship. Yes, Lordship. Paragraphs are 5, 18, 19, 20, Lordship. 5, 18, 19, and 20, Lordship. Paragraph 5 talks about the office memorandum which the government has relied upon, Lordship.
Yes, please.
Paragraph 5. By the subsequent office memorandum dated 8/10/2018, issued by the Government of India, keeping in mind the statutory enactment of the Rights of Persons with Disabilities Act 2016, a fresh set of guidelines in the supersession of the earlier guidelines were issued, which inter alia are as follows. 1. A government employee who is a caregiver of dependent daughter, son, parents, spouse, brother, sister with specific disability, as certified by the certifying authority as a person with benchmark disability as defined under Section 2R of the Rights of Persons with Disabilities Act 2016, may be exempted.
This is the OM referred by the government.
Yes, Lordship. Yes, Lordship. It is part of Annexure C to the government's affidavit, Lordship. Annexure C.
Yes.
Yes, Lordship. Clause 2. The term specific disability as defined in the Schedule to the Rights of Persons with Disabilities Act 2016 covers locomotor disability, including leprosy cured persons, cerebral palsy, muscular dystrophy, and attack victims. 2. Blindness, low vision, deaf, hard of hearing, speech and language disability. I have this disability, Lordship. 6. Speech and language disability, Lordship. Since I'm a patient of Down syndrome, Lordship, I have this difficulty, Lordship. 7. Intellectual disability, including specific learning disabilities and autism spectrum disorder. Mental illness, disability caused due to neurological conditions such as multiple so-and-so. The rest may not be relevant for my case, Lordship. If your Lordship may allow me to take your Lordship to paragraph 18, Lordship. The second last page, paragraph 18, Lordship. Various other provisions have been incorporated in the Act to ensure that the persons with disabilities do not suffer from any disadvantages. It is in that context the role of the parents become critical and crucial and important and in any way cannot be undermined. It is in that context the service conditions of the employees, more particularly those who are having physically challenged dependents relating to transfer, are sought to be governed by issuing the aforesaid office memoranda. 19. In view of the above, the court is of the opinion that even if the state of Assam has not framed any such memoranda, rules, or regulations, it would be under legal obligation to follow the principles mentioned in the aforesaid memoranda in respect of the employees having similar problems. This is important, Lordship. 20. Accordingly, this court would hold that till such adoption or framing of any appropriate rules or memorandum in this regard, the aforesaid memorandum issued by the central government ought to be followed by the state government, since the aforesaid memorandum had been issued for effective implementation of the provisions of a parliamentary enactment applicable to the state of Assam, Lordship. The principle applies in this case also, Lordship. There's no specific memorandum even in the case of state of Nagaland, Lordship. But there's a clear direction that even in the state of Assam, It has to be applied principally, Lordship. Now, 2021 SSC, Lordship, the last authority I would like to place, Lordship. 2021 SSC online, Gauhati 1309, Lordship. Lordship. Paragraphs are 8, 9, 11, Lordship. Sorry for troubling your Lordships to take to this paragraphs, Lordship. 8, 9, 11, Lordship. Paragraph 8. In the case in hand, the petitioner has annexed for office memorandum, a number of office memoranda, and also office record instruction, as have been indicated above. From the record office instruction, it transpires that if the husband and the wife are working in the same department, posting of both spouses together at the same station where required level of facilities are available is to be considered to enable them to lead a normal family life and to look after the welfare of the children, especially till the children attain 18 years of age. This is also important, Lordship. The office memorandum dated so-and-so 14 has formulated that government employee who has disabled child serve as the main caregiver of such child, and thus any displacement of such government employee will have to appearing on the systematic rehabilitation of the disabled child, since the new environment setup could prove to be a hindrance for the rehabilitation process of the child. In such situation, a government servant who is also a caregiver of a disabled child may be exempted from the routine exercise of transfer, rotational transfer, subject to the administrative constraints. The subsequent guidelines have also highlighted the same position. The office memorandum dated 8/10/18, this is the present OM Lordship, is on the subject exemption from the routine exercise of transfer, rotational transfer. It mentions that a government employee who is a caregiver of dependent daughter, son, parents, spouse, brother, sister with specific disability, as certified by the certifying authority as a person with benchmark disability as defined under Section 2R of the Rights of Persons with Disabilities Act 2016, may be exempted from the routine exercise of transfer, rotational transfer subject to the administrative constraints. Para 9, Lordship, this is also important, Lordship. It appears from the documents annexed to this writ petition that the child of the petitioner, born on 11/3/12, is suffering from Down syndrome. This is the same medical condition, Lordship, associated with deficit hearing impairment of 40%, with mental retardation and deficit in intellectual functioning. The petitioner and his wife are treating the child at different medical institutions, including so-and-so, Institute of Mental Health, Dispur, so-and-so, Gauhati. In the letter dated so-and-so, the Commandant 17th Battalion Assam Rifles were forwarding the representation of the petitioner had also opined that the child of the petitioner required constant medication and supervision of the parents. He had also recommended for extension of the tenure of the petitioner for a term period of 1 year to look after the mentally retarded son. 10, the last paragraph, Lordship. Lordship, if I may allow to read only 11, Lordship, 11. In view of the observation made above, this court deems it appropriate to dispose of the writ petition with a direction to the competent authority to take representation filed by the petitioner on board for reconsideration. While exercising the representation, the competent authority shall also take into account the official guidelines regarding exemption from routine exercise of transfer, rotational transfer, as have been formulated by the office memorandum, so-and-so, and government, and shall thereafter dispose of the same by passing a speaking order as expeditiously as possible, preferably within a period of 1 month. The order so passed shall be communicated to the petitioner forthwith. It is further observed that till the representation is disposed of by a speaking order, the order of transfer, insofar as the petitioner is concerned, shall not be given effect to. In this case, the representation was on medical grounds, but it was not considered by the authorities. So this honorable court has given the direction to consider even the office memorandum, Lordship, while considering the representation, Lordship, on medical grounds. Therefore, placing reliance on all the authorities, Lordship. Lordship. If I may be allowed to rely on the government's affidavit, Lordship. Affidavit in opposition filed by respondent on 1, 2, and 3. Yes, Lordship. 1, 2, and 3. Lordship will find it. Page 9 starts with the representation, and the next page starts the medical documents, Lordship. May I read it, Lordship? Yes, Lordship. May I make an attempt, Lordship?
Yes, please make an attempt.
To whom it may concern, Lordship. Respected sir, ma'am, this is to certify that Mr. So-and-so, 3 years old son. So-and-so, this is the son, Lordship. EYHO, Lordship. Lordship. Son of Mr. So-and-so. So-and-so, and this is the husband's name, and the next is the wife's name, the mother's name, Lordship. The present respondent number 4, Lordship. Is a Lordship. My apologies, I cannot make out the handwriting, Lordship. But the relevant is with Down syndrome, Lordship. With Down syndrome and congenital heart disease, Lordship. Congenital heart disease, Lordship. Lordship.
Next time you should not allow the court to do your work, okay? Please give type copies. Okay? I hope you yourself is unable to read out.
Lordship, I can read. Down syndrome and congenital heart disease.
Read from the beginning. Read from the beginning.
Tis to whom it be concerned, respected sir, madam, tis to certify that Mr. Eko Rasho, 3 years old, son of Mr. Wichirako Lashu, Sichikini Konyak, is a special needs child with Down syndrome and congenital
Is a special need child.
Lordship.
Is a special need child.
Special
need child. Yes.
needs child with Down syndrome and congenital heart disease. As per the condition of the child needs. As the condition of the child needs special care and attention, and is advised
The child needs special care
and attention
and is
advice for frequent hospital visits and is advised for frequent hospital visit to
even that person.
his health.
Even that person who can read, if he is taking the assistance of others, maybe it will be difficult for this court.
Because your lordship is a doctor's handwriting. So that is why I did not dive. Because I could not make out. This is doctor's handwriting.
Hospital visits to regulate to regulate.
May not be regulate because it will be wrong English.
No, how can regulate be wrong English? It fits into that sentence. You just see, and is advised for frequent hospital visit to regulate his health. I think that is the only word I can make out. And if you say it is wrong, I think you will have to bring some.
If your lordship is making out that, who am I to say that it is wrong?
Yes, Mr.
So, Lordship, this is the certificate issued by the medical officer, Lordship.
Okay.
Considering all the aspects, Lordship, my respectful submission before this Honorable Court, Lordship. The petitioner has failed to make out a case, Lordship, for interference by this Honorable Court. They transfer an order, both the orders. Both were issued in public interest, Lordship. And the petitioner has failed to make out a case that it was issued in violation of the statutory mandatory rule or malified intention. Only a vermin is malified intention, but mere making an averment will not suffice for interference of this Honorable Court. It has to be sufficed, it has to be satisfied by the courts. And on this exceptional case where my transfer has been retained, Lordship, it is on medical ground. There's no record to show that the government has any personal interest, Lordship. In fact, it is a general transfer modification order where 9 of the associate professors were affected, Lordship. It is not only the petitioner and the respondent, Lordship. Altogether 9. It is a general transfer order, Lordship. General modification order where it was issued in the public interest. Though it is silent that no specific reasons were made. But it is apparent from record that immediately after receiving the order dated 10/10/2022, I have made a representation on 12/10/2022, Lordship. And on considering all these records, medical documents, I was retained back in Dimapur Government College, Lordship. Law is also very clear that this kind of medical conditions, Lordship, where he's just, my child is just 3 years old, he needs proper care and attention, Lordship, medical proper care and attention. It is not a normal condition, Lordship. And the only facility, Lordship may kindly appreciate, the only facility available in the state is Dimapur, Lordship. And it is also not a case that I should be permanently posted in Dimapur, Lordship. But considering my conditions, Lordship, may not interfere. That is my respectful submission. This is a genuine grounds, Lordship. And law is also very clear. The 2 decisions rendered by this Honorable Court, Lordship, and also relying on the Office Memorandum 2018, the disabilities, I fall under that disabilities, Lordship. Much obliged, Lordship.
Yes.
Considering the argument advanced by the counsel for the respondents and the government, some reply is required.
Yes, continue.
After
There'll be no break. Just continue.
Lordship,
I'll take 5 minutes only.
Yes, please.
I may be allowed to mention item number 14. I have a telephonic call from the respondent that we require some more time. Item number 14.
seeking time, some more time.
My lord, the petition my petition is very simple. I'm just asking for a prayer.
Okay,
to
then both
dis-
of you wait. Okay, wait. Okay, continue.
Lordship, firstly, Lordship, my learned friend argument was based on allegation of malafide. In paragraph 9 of my petition,
Yes.
I've mentioned about malafide. Why? Would you may kindly see the first transfer order? Transfer order was then 2022. And in the transfer order, it is provided that handing and taking over.
You kindly bring your mic.
Handing, yes. Transfer order provides that handing and taking over should be completed within 10 days. No release order, Lordship, despite repeated requests, no release order. She was not released. Still did no release order.
You are working in Gauhati.
No, Lordship.
You are not working
I'm
in
nowhere.
Gauhati.
I'm nowhere, Lordship.
You are nowhere.
Yes. So, while the situation was like that, within a period of 29 days, subsequent modification order was issued. Is it not malafide, Lordship? Is it not maladministration?
You prove it. You prove it that it is modified. You'll accept.
No, Lordship.
And
My submission
making
is
a mere submission that it is modified.
no, considering the sequence, Lordship, and the action of the respondent, Lordship, he should have released within 10 days, as provided in the transfer orders, because it provides that taking over the charge should be completed within 10 days. No release order. In the meantime, subsequent
Okay,
notification.
then against whom are you raising the issue of modified? Against
Authorities, Lordship, authorities.
No, it cannot be like that. Modified cannot be general. It has to be against specific authority.
That is why
That is why against whom are you alleging modified?
That is
Have you stated in your petition that this is the officer, that is the officer?
No, Lordship.
Who has resorted to this?
No, Lordship.
And therefore his action or her action amounts to malafide? And by that way, have you implemented that officer?
No, Lordship. Then you turn to paragraph 9 of my petition, Lord. I have a statement with regard to malafide intention only.
That's why the law is clear. If
Yes,
you are
Lord.
alleging malafide,
Lordship.
you have to allege against a particular person. You cannot just say that the government was acting malafide. You cannot say that.
I've just said that a new transfer order was issued with extraneous consideration with malafide intention. General statement.
No, general malafide cannot be managed.
Yes, Lordship.
Okay, what is your next, bro?
Lordship, second point, Lordship. Lordship, may kindly turn to my reply to government affidavits.
Yes.
One paragraph only, Lordship.
Yes.
Paragraph 5. Reply to government affidavits. I am reading paragraph 5. That with regard to the statement made in paragraph 5 and 6 of the Philippine opposition. Page 4. This defendant picked to state that modification of the initial transfer order dated 10/10/22 by the subsequent order dated 9/11/22 as admitted by the state respondent authorities. It is the civil law that for modification cancellation of the transfer order passed in public interest must be submitted with sufficient reasons. Here in the present case, no reason has been sent and MP order. Therefore, the MP modification order dated 9/11/22 is nonetheless in the eye of law. By filing the instant affidavit and opposition, respondent authorities are trying to defend the illegal action by giving free explanation that the rendition of respondent for at the Maporo College by the environment notification order dated 9/11/22 was met on humanitarian ground. It is settled law that when the statutory functionary makes an order, its validity must be judged by the reasons so mentioned and cannot be supplemented by fresh reason, addition or inability, or otherwise. Otherwise, an order bad in the beginning may, by the time it comes to the board on the point of challenge, get validated by additional grounds therefrom it. Therefore, the impugned order dated 9/11/22, which is prima facie illegal, cannot be validated by the explanation brought in by the authorities in this hearing. As such, it is effective where the difference of this court is called for. Moreover, the office memorandum dated 8/10/2018, relied by the respondent authorities, is not applicable in the state of Nagaland, as no notification has been issued by the state for application of the same in the state of Nagaland. For application of the OM, which was issued, which was referred to by the counsel for both the parties, lordship, Mr. Respondents and the public respondent, no notification has been issued by the state government for application of this notification. So let the government council justify whether this one is applicable, whether any notification has been issued for application of this investment program. Thirdly, lordship, as I've submitted, I have nothing much to see on the disabilities and the sickness of the petition, respondent number 4 son. I'm just questioning the modification order.
Okay.
I know my learned friend has referred to the modification order that the modification order was issued in public interest, which is clearly mentioned in the impugned modification order. Lordship, similar case which I have referred to, 1997 GLT. In that impugned modification order, it was also clearly mentioned that the modification order is issued in public interest. However, court finds that no, there is no reason assigned in the modification order and quash. Therefore, this honorable court has to examine whether that impugned order has been issued in public interest or not.
Yes.
That's all.
One clarification, who is posted in Dimapur at present?
Respondent number 4.
Inspector?
Despite of interim order. After passing the interim order, this honorable court, I have submitted a representation to the principal as well as the director of government to release, taking into consideration of the interim. However, till date, no action is taken. The petitioner also served legal notice to the principal as well as the director that your action is in violation of the court's order. Therefore, the petition should be immediately released in view of the interim. However, no action has been taken.
Yes, Mr. Gauhati.
Yes, Lordship.
On the interim order was by this court.
It is good. Two 12/22.
Thereafter, have you sought for extinction
Yes, sir.
of this order?
Yes.
Will call your officers.
Lordship, let me find out Because this interim, I've communicated to the authority. I have to find out, the lordship.
Yes, Mr. Bar.
If that is
Only
true.
by disobeying this order, your transfer has to go. Your transfer has to go. Interim order passed by this court.
Yes, under representation, the legal notice I've served.
This order, why has it not been complied with?
If Lordship may kindly give some time
Why
to get
has it not
instruction,
been
Lordship.
complied with? If you are still staying in Dimapur, it has not been complied with.
If I may be allowed to get instruction, Lordship, the proper instruction as to where he is posted at the moment, Lordship.
Because once this court comes to know that actually this interim order dated to 12/20/22 has not been complied with, your transfer order has to without actually taking into, without discussing the main rate petition. Only on this.
Lordship.
It is on record, lordship.
Then Mr. Ma, we are calling the officer. We are calling the officer.
Your lordship, allow me some time. Let me find out.
The orders of this court.
Let me find out, your lordship. Otherwise, I've communicated the interim order to the authorities, your lordship. Let me find out. Whether it is true or not.
On the next day, if we find that the petition, the respondent number 4,
Yes.
is still continuing in violation of the order passed by this court on 2/12/23,
Your lordship.
we will cancel it. No hearing on that. No hearing on that. So what? You know the orders passed by this court.
I know. Let me find out, your lordship. Let me find out. Otherwise, I've communicated.
Mr. What is it? He's gonna counsel for petitioner. And Mr. Moin, he's gonna cover advocate. And also Mr. Mojamin, he's gonna counsel for the respondent.
For lordship.
The matter was heard and stopped. However, in the course of the hearing, Mr. Watiham, he's gonna counsel for the petitioner, has submitted that the state respondent, more particularly,
The director, lordship, responded. Who in three, lordship? Secretary, the director. Because unless the secretary, the director, direct the principal cannot release the officer from the collection.
the respondent of the claim. Has not complied with the This is seriously viewed by this court. The then Mr. Moa Inchin, the Ghana government advocate, shall, on the next date fixed, come with proper and specific instruction as to whether the respondents, particularly the respondent number 2 and 3, has complied with the order dated 2/12/2022 passed by this court. It is made very clear that if there is violation of the order 2/12/2022 passed by this court, necessary orders shall be passed against the erring officials. Listed on Monday, Tuesday,
Monday, Lordship.
listed on
Third.
3/7/2023. A copy of this order shall be furnished to the learned senior government advocate in the course of the day. Mr. Kumar, you get instructions,
Lordship, I'll find
or else we will not hear this petition.
I'll find out, Your Lord.
We will not hear this petition. We will allow the petition. We will pass necessary orders against the officials. We will draw contempt proceedings. Kindly take in mind. We will draw contempt proceedings.
Okay. Obliged.
Yes, we'll allow, we'll continue. We'll continue. We'll continue.
For admission, item number 12.
Yes, what is the case?
This matter pertains to prayer for minimum scale of pay, Lordship. Lordship, on last occasion, I was directed to clarify and apprise the Honorable Court regarding the provision on the entitlement of petitioner to the scale of pay, Lordship. Lordship, with the directive of this Honorable High Court, some similarly situated persons' case were considered and they were granted the scale of pay as per the ROP 1993, Lordship.
Similarly situated persons means the persons in the same department.
Lordship.
Okay, whether pleadings are complete, Mr. Kumar, have you filed the affidavit?
Lordship.
Okay. The pleadings are completed?
Lordship.
It is submitted by the learned counsel for the parties that pleadings are completed. And the matter can be listed for hearing. Listed for hearing in the usual course.
Obliged.
For admission, item number 13.
May it please your Lordship. Your Lordship, on 24th May 2023, Your Lordship, the Engineer-in-Chief, Your Lordship, has written to the petitioner asking him to submit all his requisite documents, Your Lordship. So, and if he is found eligible for regularization as per the scheme for regularization of workers and casual employees, Your Lordship, 2015, his case will be taken up for consideration in the month of July 2023, Your Lordship. And accordingly, the petitioner has submitted all his documents, Your Lordship. So I may be allowed to place before Your Lordship the letter as well as the receipt number, Your Lordship. So my humble prayer is that it may be accordingly disposed of, Your Lordship.
He is still in service?
Yes, Your Lordship. He has completed 30 years of service and he is on scale of pay. So he's entitled, eligible under the scheme.
Let us. You submit, you submit. This court will not dispose, okay? You
Yes.
submit, give your time. Okay?
Okay.
We'll give you time. You take steps according to the letter dated 24/5/2023. Okay?
Yes, Your Lordship, after receiving this letter, the petitioner has accordingly submitted all the requisite documents before the engineer-in-chief, Your Lordship.
Let's wait for some time. Let's wait. Okay.
Okay, Your Lordship.
MS, MS Ransom, learned counsel for the petitioner. And Mr. Washington, learned senior government review for the state's office. Mr. MS Ransom, learned counsel for the petitioners of Mr. Consequent to the letter dated 24/5/2023, written by the engineer-in-chief, PWD, Nagaland Kohima, to the petitioner,
Yes, Your Lordship.
to the petitioner, comma, the petitioner has submitted all the requisite documents that's as sought for in the letter dated 24/5/2023. So, the gonna counsel for the petitioner, therefore submits that some more time may be granted. Awaiting the action of the court. List of the tricks.
Deeply obliged, Your Lordship.
For admission, item number 14.
Your Lordship,
Yes.
I tender my apology for interruption. I thought seeing the time, Your Lordship was about to raise. Your Lordship, here I have a telephonic instruction from the respondent that they have received the copies only yesterday. So they are requested no copies.
Of the, of this order?
Yes.
Of this order?
Yes.
Of the order dated
19.
19/6?
Yes. Petition, along with the petition. So I was instructed to seek some more time. And the matter is another part is pending in the Supreme Court, which is
That
Swechana.
staying the GR.
Okay.
That has
Okay.
nothing to do with this.
So in order to reply that the prayer of the petitioner, so I say that a short time will be given to the respondent.
My lord, if the prayer of the state for seeking adjournment is on the ground that if they are to dispose of the representation and produce before this honorable court, I will have no objection. But or else my prayer is very simple, my lord. I'm just praying for a direction to dispose of that, to give a direction to the respondent number one and two.
They're saying only yesterday they have received this order. Who has received this order only yesterday? The chief engineer?
No. Respondent number 2.
That is the commissioner Nagaland. So if my humble prayer is, if this can be disposed of with the direction to dispose of the representation submitted on 13th of October 2022 within a short period of time.
What does the order 19/6/2023 speaks? 19/3/2023 timeline of the bill. Mr. B. Jimomi Leonard Government Advocate submits that in view of the nature of the prayer that has been made in the petition in connection with departmental complaint against the petitioner, the amendment needs to be clarified on receipt of required instructions from the concerned authorities. In view of the nature of the complaint, the departmental complaint. Do you instruct respondent number 1 and 3, 1 and 2 to dispose of the representation? That is nothing. Okay. Mr. MP, I think your prayer is to direct an inquiry also. This court cannot.
My lord, but if
Mr. MP, so, additional Attorney General. Again, 2 weeks time is granted to the London additional AG to comply with the order dated 19/6/2023. Please comply, sir.
For orders, item number 15.
Your Lordship, I'm representing the state respondents here. I'm yet to receive instructions, so I pray that the 3 weeks time may be allowed to me.
And Lordship, and also as per the order dated 16/5/2023, Lordship, we were directed to take dusty service upon respondent number 4, that is the NPSC, Lordship. And we have already done, and we have also filed our affidavit in effect to that, Lordship. We filed our affidavit on the 8/6/2023.
Where is your affidavit? 8/6/2023.
Yes, Lordship.
This is the respondent number.
That's the service upon respondent number 4, Your Lordship.
By the order dated 16/5/2023, the petitioner was directed to take steps for service of notice upon the respondent number 4 by dusty process within a week's time. Within a week's time. Within a week's time. In compliance to the order dated, in compliance to the said order, a letter counsel for the petitioner, has taken steps and has also filed the affidavit dated 8/6/2023 to that effect. The service upon the respondent is therefore concerned. Mr. Moa, the London government advocate, 6 for 3 weeks time to file an affidavit in opposition on behalf of the state respondents. Where is the law? Mr. Abdul.
Lordship, in the meantime, if the intern continue. Much obliged, Lordship.
Okay, for admission, item number 20. hearing item number 16.
Lordship, the media has fixed for final hearing for hearing today.
For hearing, we'll take up after vacation.
After vacation.